We are on record today regarding a petition that was filed requesting the termination of Eric Young's parental rights as it relates. May I have the names of our participants, please?
Lee Heiss, lawyer guardian ad litem.
Nastasia Thomas, counsel for the department. Conrad.
Leslie Conrad, Fostering Solutions, foster care worker.
Michael McFarland, attorney for Eric Young. Mr. Young, please introduce yourself.
Oh, we lost him. That's strange. Well, Mr. Young was available to us up until just a moment ago. Mr. McFarland, you had the opportunity to speak with him as well, did you not?
I did, Your Honor. He may have walked out. I don't know. He was requesting another attorney, so maybe we can check with jail to see if he.
Oh, there it is.
Mr. McFarland, representing Eric Young. Mr. Young, can you please introduce yourself?
Sorry, that broke up a little. Could you give us your name one more time, please? Yeah, that broke up too. Can you maybe get a little closer?
Eric Young.
There we go. Got it. Perfect. Thank you. So, Mr. McFarland, would you confirm you've had a chance to talk with your client?
I have, Your Honor.
Very good. Do you know, does he have a copy of the petition?
He does, Your Honor.
Very good. Did you ask him if he has any Native American heritage?
I have, Your Honor. He indicates no.
All right. And what about any other cases that may concern this child? Is there any other cases that you're aware of, child support, custody, guardianship, etc.?
Did not ask that question, Your Honor.
All right. So we'll take that one to him in a moment. Do you know whether or not he would like the entire petition read?
I have asked him. When I asked him, he indicated not. I can maybe ask the court to ask him again.
Okay. We'll revisit that as well.
And he does have a couple of motions when appropriate for me to make.
All right. Why don't you go ahead?
Your Honor, the first motion Mr. Young wishes for me to make is he would like Your Honor to remove yourself from this case. He believes there's bias. He indicates a memory of an earlier hearing where you personally advised DHHS to amend a petition and to bring it back. He feels that you are acting as counsel for DHHS and not neutral. And so that's his position as to why he would wish to have this case transferred to another judge.
Okay. Ms. Thomas, would you care to weigh in on that?
Your Honor, I don't believe that you have a personal bias against Mr. Young at all. I think that the hearing that we were at, in which we were ordered to refile the petition on Mr. Young, was solely regarding the child's permanency and the options available to him given the circumstances of both of the child's parents. So I do not believe that you have a bias against this individual or that you should recuse yourself.
Do you wish to be heard, Ms. Heiss?
No, thank you.
Very good. I would concur with Ms. Thomas. She has accurately recited the circumstances of the case. The court has an obligation to look at permanency and stability and whether or not progress is being made under the file and whether or not that would mean that the child can go home to a parent. We were hoping very much that Ms. Samantha Stout would make progress to the extent that we wouldn't have to pursue evaluation of whether or not her parental rights should be terminated, and therefore Mr. Young's rights would not have been affected either. But given the circumstances in her efforts and the pending termination petition, it's necessary to look at whether or not Mr. Young's rights should be affected as well, given the goal change of adoption for credence. So it was for those reasons that the court ordered the petition to be refiled, I should say, because at the outset, I had dismissed the petition given the high bond and the lack of immediate risk of harm to this child as a result of Mr. Eric Young's incarceration. So it's in the name of looking at permanency options for your child. So it's not biased and I'm not going to recuse. Next motion.
Your Honor, the second is collateral estoppel. Mr. Young has cited to me a case involving a probate matter. Essentially, he would like a trial. I have a jury demand for a trial on this matter. He would like that to be heard after the criminal case. I think in reality, the court's docket is probably a trial in this case would be after January, as his criminal trial is scheduled for the end of January. But in the event that the court schedules it before his criminal trial, he's asking the court not to do that as criminal estoppel. And he has a case number I can ask him to cite if the court would like me to. And I would like for him to at least put that cite on the record.
Well, for purposes of jury trial, the earliest jury trial that I could give you, which I would assume would be 2 days, but if it's only 1 day, then I can get it in sooner. What, do you anticipate that it would be 1 day or 2 days, do you know? Well, I mean.
Well, who's the attorney for Mother, Your Honor? This is the petition against Mother. I don't.
We're only here today for your question.
Just for him? Well, I don't know. That's what I'm saying. I don't know how long. Are these going to be bifurcated trials, 2 separate trials?
Yes. So, Ms. Thomas, how many witnesses do you anticipate calling? If you know.
Your Honor, we would be down to just 2 witnesses essentially, because we are not trying to establish the truth as it relates to the criminal allegations and that petition, which is sincerely just about his incarceration being unavailable to the child and the child's needs. So for our purposes, we could do this within a day.
All right, well then I can give you Friday, March 8th.
Your Honor, I think maybe my motion would be more right at a later date, since essentially we would not be proceeding with this abuse and neglect termination trial until after the criminal trial. And if that does arise, I can re-bring up that motion.
Do you know when the criminal trial is scheduled?
The end of this month, Your Honor.
All right. So we can set the jury trial date for March 8th, 2024 at 9 a.m. And a final retrial on that. Maybe next month. Closer to the trial date, I could give you 11 a.m. on Tuesday, March 12th.
That's fine.
Oh, no, that's after the,
Yeah, you're right. That's it.
can't go up that far. All right, why don't we go with Wednesday, February 14th at 1 o'clock? Or we'll call it 1:15. So 1:15 p.m. for a final pretrial as it relates to the jury trial and the request for termination of parental rights, Wednesday, February 14th. Does that work?
At what time again, Your Honor?
It'd be 1:15 p.m.
It does.
All right.
I guess the last motion I have is my client, when we were having a discussion, wished to have another counsel as he felt there's a breakdown between the relationship between myself and him. I guess I would inquire if he still wishes for me to make that motion, Your Honor.
All right, let's go to Mr. Young. Deputy Answer, would you please swear in Mr. Eric in?
Please raise your right hand. Do you wish to be sworn in so you can testify?
It don't matter. It's not what you want to say.
All right, let's go to Ms.
Okay, so I'm having trouble hearing you, but it sounds like you're refusing to testify. You don't want to be sworn in?
No, we can go. What I gotta get sworn in for?
It's part of the procedure, sir.
So that we can count on you telling the truth.
Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Sure.
Mr. Young, you had said that you, in a conversation with me, that you said that you want me to ask the court to have another attorney appointed for you as you felt there was a breakdown in the attorney-client relationship. Do you still wish for me to proceed with that motion today?
I would wish for you to come see me because I'm not understanding what all this stuff is about.
So you still wish for me to be your attorney and visit you in jail? Is that what I'm hearing?
Yeah.
I can do that. So that answers that, Your Honor. Thank you.
Mr. Young, do you have a copy of the petition?
Yeah, I do have a copy of the petition, but what I'm saying is I'm not understanding this anymore. Like I was.
Well, it sounds like Mr. McFarland's gonna come and see you about that, but I just have some procedural things to go over with you today. I'm not gonna discuss the substance of the petition. Mr. Young, I need you to listen, please, for a minute. I'm not gonna discuss the substance of the petition with you today. But you have certain rights at a preliminary hearing, and so I'm gonna go through those with you. You have a right to have the petition read in its entirety into the record. So there are several pages, including 6 pages of specific allegations that you would have the right to have read onto the record. You also have the right to waive that right.
Well, read it off.
I'm sorry, what?
Read it off.
He wishes you to read it all, Your Honor.
Okay, so you wish me to read the petition. All right, I can do that.
Your Honor, before you start, would you tell me what date yours is dated? There's so many supplements and amended and.
Okay, so it looks like the one I have, the most recent one I have is dated November 15th. Is that accurate, Ms. Thomas?
Yes, Your Honor, it was signed on November 13th, but I believe it was stamped on the 15th, yes.
Thank you.
May I ask Mr. Young if he has that copy, Your Honor? Mr. Young, do you have the copy signed November 13th and file stamped on the front November 15th?
I got December 13th and I got November 15th.
Okay, thanks. We'll let the judge read then so you can follow along.
All right, very good. Page 1 simply indicates the name of the child, date of birth, the name of Mr. Young, his date of birth, and the name of the mother and her date are present on that cover page. It indicates there is one or more pending or resolved cases within the jurisdiction of the Family Division of the Circuit Court involving the family, subject to the petition, and that there has been a confidential case inventory filed indicating the same. Just by reference, that is a DS case. Paragraph 4 indicates the allegations that the child comes within the provisions of MCL 712A.2B 1 through 6, specifically alleging the parent or other person legally responsible for the care and maintenance of the child when able to do so neglected or refused to provide proper or necessary support, education, medical, surgical, or other care necessary for the child's health or morals, or that he is subject to the child to a substantial risk of harm to his mental well-being, or abandon the child without proper custody or guardianship. The box that's checked as applicable for purposes of today's hearing indicates the allegation that the home or environment, by reason of neglect, cruelty, drunkenness, criminality, or depravity on the part of a parent, guardian, non-parent, adult, or other custodian, is an unfit place for the child to live. The next applicable paragraph is 5, the reasons why it is contrary to the welfare of the child for the child to remain in the home. And that is indicated as there is a substantial risk of harm to the child due to Eric Young's previous conduct and inability to safeguard children in his care. CY has been placed in out of home care since 11 of 2022. Father has been incarcerated since 2 of 2023 and currently faces 8 felony CSC and CSC related charges while being held on a $93,000 bond. Father is a registered sex offender. Father cannot provide care or custody to the child. No barriers that existed at the time the child's removal have been addressed during the 12 months CY has been in care. 6, the reasonable efforts made to prevent the removal of the child include case management services provided include, but are not limited to CPS investigations, safety planning, placement with non-respondent parent, foster care case management, medical and dental care for the child, supervised parenting time, family team meetings, transportation assistance, incarcerated parent protocol, relative family search, and home assessment and relative placement. Paragraph 7 indicates the specific allegations are, and then says, please see the attached addendum for the essential facts that constitute an offense against the child under the juvenile code. This particular form, which is effectively page 3, in paragraph 8, has a request to authorize the petition and to terminate the parental rights of the father to the child, signed by Ms. Conrad and Ms. Thomas on November 13th, 2023. Addendum to supplemental petition for jurisdiction and termination of parental rights at initial disposition for respondent father is next. Now comes petitioner by and through its legal counsel, Ms. Stasia J. Thomas, and in compliance with this court's order, submits this supplemental petition for jurisdiction and termination of Mr. Young's parental rights. In support of the relief requested, petitioner states the following. Party identification. 1, Samantha Stout is a respondent parent in this matter and is the biological mother of subject minor CY. Ms. Stout is currently residing in Lenawee County. 2, Eric Young is the legal father of the subject minor. Jurisdiction and venue. 3, the subject minor is not a member of or eligible for membership in an American Indian tribe or band. Respondent parents have been asked at multiple court hearings and have explicitly denied that subject minor is a member of or eligible for membership of an American Indian tribe or band. 4, this court has ongoing jurisdiction over the subject minor. 5, the subject minor is a resident of Lenawee County and is currently placed in the care and custody of the department, placed in an unlicensed relative placement. Factual allegations, respondent father. 6, on or about 9/28/2022, the department filed a petition for jurisdiction and termination of parental rights at initial disposition. Parent petition 1, closed parent. against Mr. Young following a complaint received in July 2022, which was ultimately substantiated as a Category 1 for improper supervision and threatened harm. 7. Petition 1 alleged a substantial risk of harm to the minor child as Mr. Young allegedly is sexually. One minor is the half-sibling of one of Mr. Young's children, and the other minor is a child of one of Mr. Young's former romantic partners. 8. On or about 11/2/2022, after a preliminary hearing on petition 1, this court removed the subject minor from Mr. Young's care and custody, releasing him to his then non-respondent mother, Ms. Stout. The child was subsequently removed from Ms. Stout's care and custody. 9. Mr. Young requested a jury trial on petition 1 and waived timeline requirements. 10. On or about 2/1/23, Mr. Young was arrested on criminal charges arising from the same facts alleged in petition 1. 11. This court continued to hold regular pretrial review hearings as it related to Mr. Young. 12. On or about 8/7/23, petitioner dismissed its pending petition against Mr. Young as there was no longer an imminent risk of harm to the subject minor given Mr. Young's lengthy incarceration and high bond. 13. Mr. Young remains incarcerated pending his criminal trial. 14. Mr. Young is facing a total of 8 charges and 2 felony cases, which have been bound over, and his bond is set at $93,000. A. Illinois County Circuit Court File Number 2023-21306-FC. I. Felony criminal sexual conduct first degree. Person under 13, defend 750-520-B2B. II. Felony criminal sexual conduct second degree. Person under 13, defend 750-520-C2B. III. Felony criminal sexual conduct second degree. Person under 13, defend 750-520-C2B. IV. Felony sex offenders. Failure to register 28729. B. Illinois County Circuit Court 2023-21305 FH. Felony criminal sexual conduct third degree. Person 13 through 15. 750-520-D1A. II. Felony criminal sexual conduct second degree assault. 750-520-G2. III. Felony children accosting for immoral purposes. 750-145A-A. IV. Felony criminal sexual conduct second degree. Multiple variables. 750-520C. Paragraph 15. Eric Young has an older criminal history spanning from 1998 to 2015, but of relevance is a criminal sexual conduct first degree multiple variables charge from 11/2/1992 when he was a minor. He is a registered sex offender as a result of this conviction, and duration is documented as, quote, lifetime, quote. 16. Mr. Young is the legal father of 6 other children who are not subject to this petition. The mothers of the non-subject minors have custody orders in which they have sole legal and physical custody or parenting time is at all times agreeable between the parents. Each mother has taken appropriate measures to ensure that Mr. Young does not have parenting time with the other subject minors. Removal and termination is unnecessary for those children as they are not siblings of the victim and are adequately safeguarded. A. KY and KHY, mother has sole physical of the minor. Mother and father have joint legal custody. B. JY, mother has sole physical of the minor. Mother and father have joint legal. C. YH, mother has sole physical of the minor. Mother and father have joint legal custody. D. EYG, mother has sole physical of the minor. Mother and father have joint legal custody. E. NY, mother has sole physical of the minor. Mother and father have joint legal custody. 17. The subject minor remains in the care and custody of the department and has yet to achieve permanency or finality. 18. Although there are sufficient safeguards to protect the subject minor from Mr. Young's conduct, there remains a significant risk of harm to the child's emotional and psychological well-being. The child remains in a relative placement and neither parent has made progress in the last 12 months towards permanency for the child. 19. Since being dismissed from this case, Mr. Young has failed to delegate his parental rights through a power of attorney or guardianship. Furthermore, even if he tried, the current relative caregiver is unwilling to accept an appointment without financial support. 20. On or about 10/17/2023, this court ordered petitioner to refile a petition against Mr. Young after hearing the caseworker's testimony regarding the subject minor's need for finality and permanency. Statutory citations. 21. Adjudication. Based on the above stated allegations, there has been a violation of the juvenile code under the following subsections of MCL 712A.2b. A. 1. The child is under the age of 18 and is subject to a substantial risk of harm to his mental well-being. B. 2. The home environment with Mr. Young, by reason of criminality and depravity on the part of Mr. Young, is an unfit place for the child to live. 22. Termination of parental rights at initial disposition. This petition to terminate parental rights at initial disposition is submitted under the authority of MCL 722.638 subsection 3. The department held a conference with appropriate personnel and in concurrence with the LGAL has agreed to seek termination of parental rights at the initial disposition as authorized under MCL 712A.19b. 23. Termination of parental rights. Based on the above stated allegations, at least one statutory ground for termination of parental rights exists under MCL 712A.19b3J. Is there is a reasonable likelihood based on the conduct or capacity of the child's parent that the child will be harmed if he or she is returned to the home of a parent. 24, best interest factors. As contemplated by MCL 712A.19b5, it is in the child's best interest to determine the respondent parent's parental rights as articulated below. A, the child's need for permanency, stability, and finality. CY is 6 years old. He has been in care for a year without any consistent in-person visitation with either parent. There has not been a change in either of his parents' circumstances that led to his initial removal. He needs and deserves as much normalcy, stability, consistency, safety, and security as possible throughout the remainder of his childhood. B, the child's age. The child is a young minor who needs permanency throughout the remainder of his minority, and given his young age, has a high likelihood of adoption. C, the parent's parenting ability. Eric Young has proven his inability to safeguard children in his care, as there have been multiple disclosures of sexual abuse by Eric Young made by minors with whom he has been given a co-parenting role. D, the possibility of adoption. Should the child be available for adoption, the relative caregiver who has cared for him for the past year would have the opportunity to adopt the minor child, providing him permanency within the same family unit as 2 of his older paternal half-siblings. E, the child's relationship with siblings. CY currently lives with 2 of CY's 6 older paternal half-siblings. He will be provided the opportunity to grow up in the same permanent family unit as his 2 older paternal half-siblings. The current caregiver also has established relationships with 2 of the non-respondent mothers of the remaining 4 paternal half-siblings and intends on continuing CY's relationship and visitation with those siblings. F, the child's bond to the parents. The minor child lived primarily with his father prior to removal and is reported to have had an appropriate parenting time parent-child bond developed with Mr. Young. Mr. Young has now been incarcerated for 9 out of the 12 months that CY has been in care, and the parent-child bond has been impacted by their physical separation and the limited opportunity for parent-child communication. G, the advantages of a relative caregiver home over the parent's home. The relative caregiver provides a safe and stable home that offers routine and predictability, as well as protection from risk or unsafe individuals. The home offers the minor child emotional support, physical affection and nurturing, a sense of belonging to a family unit that includes half-siblings and a caregiver that CY seeks comfort, help, and guidance from. Mr. Young is incarcerated and facing 8 felony CSC and CSC-related charges and cannot currently provide the child with a home or stability. H, the parent's visitation history with the child. Prior to his 2/1/23 arrest and subsequent incarceration, Mr. Young visited with CY in person only 1 time, following CY's removal on 11/3/23. Since his arrest, he's been provided with the opportunity for regular video chats, 15 minutes in duration, with the child, facilitated by the agency and/or the caregiver, which he has engaged in when scheduled. I, the child's well-being while in care. The child's caregiver has committed to meeting all of his needs for the entire year he has been in her care and has agreed to continue doing so on a permanent basis. J, the length of time the child has been in foster care. CY has been in care for 12 months at the time of this petition, and although not 15 of the last 22 months, it is a significant amount of time with no progress made for him to remain in foster care. K, the opinion of experts, including LGAL, therapists, caseworkers, psychologists, etc. The minor child's LGAL, Lee Jameson Heiss, reported during the most recent review hearing that she supports the permanency goal of adoption for CY and the submission of this petition requesting the court take jurisdiction in regard to Mr. Young and terminate his parental rights. Relief requested. Wherefore, for the reasons stated above, the petition requests this honorable court issue an order maintaining the subject minor in the care and custody of the department to remain in his current relative placement. 2, authorize this petition for jurisdiction and termination and initial disposition against Mr. Young. 3, make judicial determination that reasonable efforts to prevent removal and to reunify Mr. Young and the subject minor are not required pursuant to MCL 712A.19A2A as explained in N. Ray Rippey, 330 Mishap 350 355 948 NW2D 131 2019. 4, suspend parenting time pursuant to MCL 712A.19B4. 5, set this matter for an adjudication trial and termination hearing. 6, take jurisdiction over the subject minor pursuant to MCL 712A.2B1 and 2. 7, terminate the parental rights of the above named parent pursuant to MCL 712A.19B3, 4, and 5. And 8, any other relief this court deems adequate and appropriate under the circumstances. Respectfully submitted, 11/13/2023, signed by Nastasia Thomas on behalf of MDHHS and Ms. Conrad from Fostering Solutions. Entitled to an attorney, which is why Mr. McFarland is here. He will be here at all subsequent hearings. If you wish to retain your own attorney, you're always welcome to do that. That person would have to reach out and file a substitution and get the file from Mr. McFarland. The court must determine today if the petition should be dismissed or the matter referred to alternative services. If I determine, the court may release the child, otherwise we'll be continuing the hearing. You have the right to a trial on the allegations of the petition, and that trial may be before referee unless a demand for jury or judge is filed pursuant to MCR 3.911 or 3.912. You have a right to seek placement of your child. The right to, you'll have the opportunity to admit or deny the allegations and make a statement of explanation. But at the end of the day, I have to decide whether to authorize the filing of the petition, if authorized, whether the child should remain in the home, be returned home, or be placed, and in this case, continued in foster care pending trial.
I submit my jury demand, Your Honor.
Thank you, received. The court may authorize the filing of the petition upon a showing of probable cause unless waived that one or more of the allegations of the petition are true and fall within MCL 7128.2b. Michigan rules of evidence do not apply other than those with respect to privileges, except to the extent that such privileges are abrogated by MCL 722.631. Mr. McFarland, do you know if your client wishes to waive the probable cause aspect of this, or if he wishes to have presentation of proofs on that?
He wishes that presentation of the proofs on it, Your Honor.
Okay. Ms. Thomas, did you want to tackle that today, or given what time it is, can I offer you the opportunity to come back on Tuesday around 10 a.m. to allow for further proofs?
Yes, Your Honor, I would prefer Tuesday at 10 a.m. to continue the preliminary hearing.
All right. Any objection, Mr. McFarland?
No, I'll be meeting with Mr. Young prior to that date, so that's fine.
Oh, I'm sorry. I gave away 10:30 to you earlier.
Oh, that's
How
right.
about 9:30? You have Shay at 10.
That's right, yeah.
So 9:30 on Tuesday, January 16th. And we will adjourn to allow more time for the presentation of proofs as it relates to the probable cause aspect of the preliminary hearing, as which has been requested to be authorized by the department. We don't have enough time today. It's 11:52 to do that for breaking for lunch, but I think our time is well spent in allowing Mr. McFarland to talk with his client before we begin today. Mr. Young, do you want us to request the jail to have you present at like 9 on Tuesday so you can talk to Mr. McFarland again, or will you be comfortable just appearing at 9:30?
That'd be fine.
Okay.
Your Honor, may I request that Mr. Young be here personally in person? I think he has that right to be here in person.
Do you wish to be here in person, Mr. Young?
I do.
All right, we will request the jail to make those arrangements. Anything else?
No, thank you.
All right, we're in recess. All prior orders remain in full force and effect, and we'll continue our prelim to Tuesday, the 16th.
All right, we have Mr. Young here now. Mr. Malero.
Judge, may I have a breakout with Mr. Young real quick? Well, probably won't be real quick, but I do need.
Yeah, 1 second. All right, are we ready to proceed, Mr. Malero?
Yes, we are, Your Honor.
All right, we are on the record in file 23-21305-FH and 23-21306-FC, People versus Eric Michael Young. We are here for a final pretrial in the filing 305 and a pretrial in filing 306. First, let me ask the attorneys to place their appearances on the record, beginning with Mr. Hartung.
Thank you, Your Honor. Doug Hartung, appearing for the people.
Salvatore Malero on behalf of Eric Young.
Okay, and Mr. Malero, where do we stand with Mr. Young's cases today?
Your Honor, I believe we have reached a resolution. I'm going to place it on the record. If I am mistaken in anything, I'm sure Mr. Hartung will provide clarification. So, Your Honor, on the 305 file, Mr. Young will be pleading no contest to count 1. On the 306 file, Mr. Young will be pleading no contest to a CSC second with a supplement, 1 supplement, and he'll be pleading guilty to the supplement or habitual notice. So it's no contest to the facts, a guilty on the supplement. We have a Killebrew agreement of Mr. Young will receive a sentence of 8 years on the minimum. And then we have a request on bond conditions after the plea is entered. I think that.
All right.
Oh, and the count 1 is a 15-year felony, And the CSD second is a 15-year felony.
Okay, Mr. Hartung, is that a complete and accurate statement of the plea agreement?
I believe it is. I just want to make sure on the record that the sum that he will plead guilty to is for both files. So
Okay,
he'll create,
that's fine, Judge. Or, I mean,
he'll
that's,
create a 22.5-year cap on the top end. We've agreed to an 8-year sentence on the minimum. The victims' families have approved this. And these sentences would run concurrent.
yes, that's right. Sorry, correct. Yes.
Okay, so
Yes, that
the
is correct.
supplement is, I'm sorry, what was that again? It's a second offense?
It would be a second offense, so it would increase it by 7.5 years on each file for this particular plea.
Okay, Mr. Young, would you raise your right hand, please? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
Yeah.
You are Eric Michael Young?
Yes.
You've heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead guilty today in file 23-21305-FH? I'm sorry, plead no contest today in that file to third-degree criminal sexual conduct?
Yeah.
Is it also your intention to admit a second habitual offender notice?
Yes.
Do you understand that with respect to that charge, then the maximum possible penalty would be 22.5 years in prison?
Yeah.
With respect to the 23-21306-FC file, is it your intention to plead guilty to count 2 criminal sexual conduct second degree? I'm sorry, I was not able to hear your answer.
Yeah.
And is it also your intention to admit a second habitual offender notice in that file as well?
Yeah.
And do you understand that with that second offense notice that the maximum possible penalty for that charge would again be 22.5 years in prison?
Yeah.
Are you satisfied with Mr. Malero and the advice that he's given you?
Yeah.
Do you wish neither the prosecutor, defendant, or anyone acting on the defendant's behalf has discussed possible sentence with the court other than as we've discussed it on the record here this morning? Is that correct, Mr. Hartung?
Yes, Your Honor.
Mr. Malero?
That is correct, Judge.
Is that also your understanding, Mr. Young? I'm sorry, the microphone there is bad. Was that a yes?
Yeah. Yeah.
If a guilty plea is accepted, there'll be no trial. That means you'll be giving up the rights that you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You do have the right to a speedy public trial by jury. You could ask for a non-jury trial, and if the prosecutor and court agreed, you could have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at your trial, to have the witnesses against you appear at your trial, and to ask those witnesses questions. You have the right to have the court order any witnesses that you have for your defense to appear at your trial. You have the right to remain silent during your trial and not have that silence used against you. However, you also have the right to testify at your trial if you wanted to testify. You understand, Mr. Young, that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial. Sorry, I wasn't able to hear what you said.
Yeah.
Do you also understand that any appeal from the conviction and sentence pursuant to the plea would be by application for leave to appeal and not by right?
Yeah.
If you are not a citizen of the United States of America, conviction of a crime can result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you understand, Mr. Young, that by entering a plea to these offenses that you will be required to register under the Michigan Sex Offender Registration Act? Sorry, the microphone didn't catch your voice again.
Yeah.
How do you wish to plead to the charge in file 23-21305-FH that on or about June 10, 2022, in the city of Adrian, county of Lenawee, that you did commit the offense of criminal sexual conduct, 3rd degree?
That would be no contest, Judge.
Okay, so Mr. Young, if you want to plead no contest, you need to say no contest. Sorry, the microphone's there, not good there.
Contest.
Can you try sitting a little closer to the device?
No contest.
Okay, thank you. And in file 23-21306-FC, so I don't have years on this.
This is the one that we amended and filed with the court and gave to Mr. Malaro yesterday.
Oh, I'm sorry.
That's okay. You may not have received it yet. I can put those dates on the record if you'd like me to.
Go ahead, please do.
It is December 1st of 2013 through December 31st of 2015 for counts 1, 2, and 3. And then count 4 was the June 10th of 22 date.
Okay. So Mr. Young, how do you wish to plead to the charge that on or about December 1st, 2013 through December 31st of 2015? And so it doesn't have city, township, or village in my information.
That's Adrian City.
In the city of Adrian, county of Lenawee, that you did commit the offense of 2nd degree criminal sexual conduct. I was not able to hear anything there. Sorry, can you try one more time?
No contest.
Okay. Has anyone made any threats or promises to you to induce you to plead no contest to those charges? I need you to sit closer to the device. It's not getting your voice.
No.
Do you understand that if I accept your plea, you're giving up any and all claims that your plea is given as a result of threats or promises that were not disclosed to the court on the record here this morning, or that it was not your own choice to enter the plea?
Yes.
Is the prosecutor or defense counsel aware of any promises, threats, or inducements other than the plea bargain to induce Mr. Young to plead no contest?
No, Your Honor.
Judge, I think we should probably add that all remaining charges would be dismissed at sentencing. Other than that, there are no other inducements other than it's indicated on the record.
And I presume you're in agreement with that, Mr. Hart?
That's accurate.
Okay. Mr. Young, other than as we've discussed on the record this morning, has your attorney promised you any particular sentence or estimated what your sentence would be?
No.
Is it your own choice to plead no contest today?
Yeah.
All right, Mr. Malaro, would you like to review the factual basis?
Sure.
I can do that if you prefer, Mr. Malaro.
Yeah, I would prefer Mr. Hartung to.
Okay.
That's okay with the court. I'm going to summarize the testimony of the 2 minor victims from the preliminary examination that was held before Judge Morgan on March 16, 2023. In file number that ends in 305 FH, the minor witness, whose initials are GW, who was 15 years old at the time of the incident, testified that she was digitally by the defendant, Eric Michael Young, at a residence on Budlong Street in the city of Adrian, Lenawee County, Michigan, and that the assault happened over a period of time in the house that Mr. Young was living at on Budlong Street. And in file number 306, with the dates between 12/1/13 and 12/31 of 2015, the minor victim, who was at age 8 at the time of this particular incident, testified that she also was digitally by Eric Michael Young in her bedroom on Treat Street in the city of Adrian, Lenawee County, Michigan, during that time frame. Both of these young victims testified, and their mothers testified as well, that the defendant had a romantic relationship or had a romantic relationship with each of the mothers and made access to the minor children through that avenue.
All right. Mr. Malaro, do you agree that that satisfies the factual basis?
I would agree, Judge.
Right. Has the court complied with MCR 6.302 B, C, and D, Mr. Hartung?
On that part of the plea, yes, Your Honor.
Oh, and I apologize. So we need to review the habitual offender. Mr. Young, do you agree that on or about February 18, 1998, you were convicted of felony breaking and entering into a building with intent in the 37th Circuit Court, that's Calhoun County, Michigan?
Yes,
Do you also agree that on or about November 6, 2013, that you were convicted of possession of a controlled substance, cocaine, heroin?
I'm sorry, do we only need to do one?
Oh, I apologize. Yeah.
We're only doing one, but we're only taking it for one, Mr. Malaro.
Right.
Okay.
Oh, are you gonna do one for each, I take it? Is that what we're doing?
They apply to both files.
Yeah, I think the one conviction can apply to both files. So I think
Yeah,
we're all
okay.
set.
Thank you, Judge.
My eyes were on the notice that I had, so
That's right. You had a tough morning, Judge.
no need for additional. All right. So I'm sorry. Has the court complied with MCR 6.302 B, C, and D, Mr. Hartung?
Yes, Your Honor.
Mr. Malero?
Yes, Judge.
All right, I will accept the pleas then. They have been given understandably, voluntarily, and accurately. Mr. Young has had full knowledge of his rights and he's had competent counsel. Other than, as we've discussed on the record here today, of course, not made any other agreements regarding the possibility of plea or sentence in this case with the prosecutor, defense attorney, defendant, or anyone acting in the interest of any of them. I will refer this matter to the probation department and set sentencing for March 8th. At 8:15 a.m.
Judge, two other matters, if I may.
Yes, go ahead.
First, Mr. Young would request to be present in person for his sentencing. And the second request is Mr. Young's asked me to request of the court that he be granted a PR bond pending sentencing so that he could spend that time with his family. He has I think a 9-year-old son that he, I think this court might be familiar with, is engaged in a considerable amount of parenting time litigation, and he would like to spend some time with his son prior to the sentence being imposed. That's our request.
Mr. Hartung, people have a position.
We would obviously oppose that request, Your Honor. It's only a very short period of time between now and the time of sentencing, and he's looking at a rather lengthy prison term.
All right. At this point, we do have convictions on two very serious crimes, and those are going to carry with them prison sentences. And at this point, I don't feel, based on that it would be appropriate to release Mr. Young on a PR bond. So I'm going to deny that request.
All right. Thank you, Judge.
Thank you, Your Honor.
Mr. Young, you can let the officer that's with you know that you are done with court for today, and we will make arrangements to have you in person for the sentencing.
all right, thank you.
Thank you, Eric.
And